Okay, this morning I'm going to talk about appeals. We've got a couple of them in process. These three are trials that I covered on here, so I'm just coming back to give an update. Let's start with Charlie Adelson. And before I begin, I'm not an attorney, so when I read this paperwork, I'm just giving you my personal translation of it. Don't know if I'm exactly accurate, but here you go. Charlie Adelson was eventually convicted of the 2014 murder for hire killing of his brother-in-law, Dan Markell, who was a professor at Florida State University in Tallahassee. Now, so far, 5 people have been convicted of this. So it's the 2 people that they hired to kill him, the woman who acted as the middleman, and then 2 of the Adelsons, Charlie, who was alleged to be the kind of the guy who was given the money and making the connections and doing all of that. And then his mother, Donna Adelson, that's the trial I covered. She got convicted last fall. And we're all just waiting for the day they go after Wendy herself. Charlie's lawyers made 4 claims in his appeal. 1, the court should have granted a change of venue. Court should have struck the entire panel because prospective jurors were talking about the Adelson case in the jury assembly room. The court should have admitted certain text messages into evidence, and the court should not have excluded some hearsay evidence of a recorded phone call. Anyway, and this one's already been decided. An appeals court upheld his conviction, rejecting all of his arguments. He will continue to serve what he was sentenced, which was life in prison plus 2 consecutive terms of 30 years. Next up is Kouri Richins, the Utah mom convicted of putting fentanyl in her husband's Moscow Mule to poison him. Her attorneys filed for an appeal on May 26th, stating really a couple of big things here. The court's bias in favor of the state and the prosecutor's reliance, is how they worded it, on other crimes, that all of this resulted in substantial undue prejudice. Now, I think both of these things really intertwine, because what they're alleging is that Judge Richard Mrazek showed a clear bias in favor of the prosecution when he allowed substantial testimony to come in about her financial crimes. But that was the motive for the murder. Like, they very early on said, due to all of her financial problems and the crimes she was committing and how she was stealing from his accounts and doing all of these things, that was the motive leading to the murder. So in my opinion, it's fair to bring it in. But they're saying that leaning so heavily on that financial evidence was prejudice to her. Now, she does have another trial coming up because, believe it or not only is she convicted murderer, but she faces 26 other felony charges in a second case, and that was largely due to her real estate dealings. That's fraud cases, insurance fraud, more financial misdealings, all that stuff. When her defense team filed this appeal, they also filed motion for a new trial, saying that this judge should be recused and they want a new judge for the next one. The judge, Mrazek, he has recused himself from making the decision, which is the absolute fairest thing to do. He can decide if he was fair or not, and he's saying, I'm not going to decide that. I'm going to let another judge decide that. The appeal will be heard by a 7-member court of appeals, and they're going to consider whether there are grounds to overturn her conviction on any of the 5 charges. The attorney for Kouri Richins is also the attorney for Tyler Robinson. So when they filed this appeal, they also did a couple of other things. One, they said, we're not going to represent her in the second trial, the financial trial, but also if she does get any sort of appeal or anything, she'll need to find a new attorney because we can't represent her in that case. For now, Kouri Richins is serving life in prison without the possibility of parole. Carmelo Anthony also has new attorneys, and from what I understand, this is kind of an all pro bono panel of people who are trying to help him out. Their appeal was lengthy. It was 193 pages. Here's the basics. They're saying that the court erred when it restricted public access to the trial, that he has a right to have a public trial, and when the court wouldn't let cameras in there, that they violated his rights. We've discovered that the prosecutor and the defense had an unwritten agreement to exclude certain character and extraneous offense evidence from the trial. meaning this is kind of like in politics when two politicians agree to a clean campaign. Like, let's just stick to the facts. Let's just cover the policies. Let's don't get in the dirt and sling mud at each other. Well, apparently that's what these two sides agreed to. They wouldn't talk shit about Carmelo. They wouldn't talk shit about Austin and his brother. Let's keep it clean and let's just stick to the facts. And then they're saying that the prosecution repudiated that agreement. So basically the prosecution went against that agreement. And since it wasn't written down anywhere, they're saying now that they went against that agreement, which is why they couldn't put Carmelo up on the stand. I said all along, I think in a self-defense trial, you I would take the stand in your own defense. And he chose not to. They're saying that by allowing so much discussion about provocation, they limited the jury's ability to consider self-defense. So again, self-defense is when you feel like you have to defend yourself. From all the witnesses, the jury repeatedly heard that Carmelo provoked the incident. And in the state of Texas, when you provoke the incident, it's hard to claim self-defense. Like it kind of, I don't want to say it like violates the stand your ground, but it kind of is. Like you have stand your ground unless you were the one that started it. And they're claiming that the judge allowed in and the prosecutor leaned into the provocation argument, which limited Carmelo's ability to convince a jury it was self-defense. Fourth one is just in the interest of justice. Like if you read all the above and you care about justice, you should let him have a new trial. So fourth is just a summary of the previous points. You can see below the next deadline for an official appellate record to be filed is August 8th. And then once the record is complete, his lawyers will submit briefs detailing the legal and constitutional errors. The appellate court will then review the case and ultimately decide whether to uphold his conviction or order a retrial or modify his sentence. So August 8th seems to be the magic date of when something will happen next. So there you go. There's your update in those three cases. And usually appeals processes, they go on and on and on, especially if a person is spending, life in prison. There are, in many cases, they can appeal more than once. They can appeal to higher courts every single time. Whether or not those courts will agree to hear the appeal, whether it changes the conviction, whether it changes the status of anything, remains to be seen. Again, I'm not an attorney, but it is my understanding that, it's pretty tough to win an appeal or get a retrial. You have to prove, A, that there's new evidence available that wasn't available at the time of trial or was held back from the trial for some reason, and now it exists. And so now we're going to appeal on that ground. Or the second one would be insufficient counsel. If you can prove that the attorneys, the judge, somebody in the situation acted egregiously, or like in the case of the Murdaugh trial, that there was somebody, the court reporter, I think it was, who did something that violated his rights. So it can be kind of anybody, jury, misconduct, those types of things. It's a pretty high bar. So they will continue to appeal, and we'll see which ones, if any of them, ever get approved.